What it did was it sent the matter back to the district court, now to Chief Judge Boasberg, who's supposed to now go through document by document and decide which ones can go to Jack Smith. But the wrinkle is, I'm not sure that the grand jury is operating anymore in the Trump matter. It's a big kind of a mystery at the moment. There's been no activity from them. And so one of the questions people have raised to me is, if Judge Boasberg does that analysis, there's no one to give it to. So there may not be anyone to give it to. So can he even do it? Is this thing just sort of dead and moot at this point? Or is there actually going to be some further development?
I'm Benjamin Wittes.
I'm Roger Parloff.
I'm Anna Bauer.
And this is the Lawfare Podcast, December 2nd, 2023. You know, it's another episode of Trump Trials and Tribulations. We had special guest Kyle Cheney of Politico. We had Roger Parloff. We had Anna Bauer. We had a live audience in the virtual jungle studio.
Among other things, we talked about Scott Perry's text messages that were newly revealed in a filing in D.C. District Court, reported on by our special guest, Kyle Cheney. We talked about happenings with New York gag orders and D.C. gag orders.
We talked about Section 3 of the 14th Amendment cases, especially Colorado.
And we talked about Anna's story about the Georgia Bureau of Investigation's report in Coffee County and how much it sucked. It's the Lawfare Podcast, Trump Trials and Tribulations, gag orders, telephones, and other stuff. All right, folks, we have had a relatively quiet week, but not a week absent interesting events. Want to start with our special guest, Kyle. We've had some interesting revelations about Representative Perry and my hero, Assistant Attorney General or acting Assistant Attorney General Clark. What did we learn this week, and how did we learn it?
Sure. So, just to zoom out a little bit, it's very crazy to me that 3 years after January 6th, there are still major plot points on the timeline that are coming out we still don't know, or we're learning. And I think this is what happened this week when the Court of Appeals, which has spent basically, there's been litigation going on. The FBI seized Scott Perry's cell phone over a year ago, and they've been trying to get court permission to access it since then. There's been a couple of rulings, including by the appeals court here, and in connection with that, the DC Circuit just unsealed a whole big batch of filings related to that litigation. But in the process, they inadvertently unsealed a very sensitive document that included a lot of the communications on Scott Perry's cell phone that were not supposed to have been accessed by the government or made public in any way. This was posted publicly on the docket for several hours before they pulled it down, and I think others, I'm sure a few others, obtained that document and found it highly newsworthy because it described some of Scott Perry's extensive contacts in support of efforts to overturn the 2020 election. We've known he was involved, but not necessarily to the granular degree that this filing revealed, and with who he was speaking, who he was reaching out to, high-level figures, Trump White House, Trump campaign, outsiders who in sort of this shadowy cybersecurity world, some very fringy people who he was strategizing with, and Pennsylvania state legislators who he was hoping would take action in their own state.
And what do we make of this? At one level, you look at it and you say, yeah, we kind of knew that Clark came to Trump's attention through Perry. Doesn't look like there's a case to be made against Perry, although maybe there is. You got kind of prohibitive speech and debate clause immunity stuff going on in there. What did you think the actual significance of, is it mostly just a storytelling, building the narrative kind of thing, or do you think there's action that's likely to follow from this in any significant way?
It's a good question. I think that for me, right as I sit here right now, this just sort of adds texture. It fills in the Perry role in all this that had been a bit murky. We've long known he connected Jeff Clark to Donald Trump. Well, the first anecdote that I included in my story was a conversation he had with Jeff Clark on December 30th, 2020, just a few days before Trump began to and then rescinded his appointment of Clark as acting attorney general, in which Clark says, "I'm nervous. I don't know if I'm ready for this." And he says, you're the man. You're ready. This is God's plan." And to me, this just gives you a glimpse into the mindset of both of these men on the cusp of this extraordinary moment on that timeline. And then there's more, because there were a lot of new names in this document that I hadn't seen before or had come up only glancingly that Perry was corresponding with, people who were affiliated with Sidney Powell, these cybersecurity experts, but there was much more correspondence going on this. And Perry was kind of viewed as a connector. They would say, "Hey, can you tell Trump this for me?" And Perry would say, "Yeah, I got you. Hey, I need to get on Fox News to talk about this." And Perry would say, I'll marshal the troops on that. And so I think people would come to him because as a lawmaker, he probably had access in ways others did not.
Anna, you had a question?
Yes. So, Kyle, one of the things that really interested me about your piece, and you noted this in the piece, and then I believe Jeffrey Clark's spokesperson kind of followed up with you about it. I just wanted to ask you about it because something that came out in this filing and that you reported on is that there were these text messages between Jeffrey Clark and Scott Perry in which they're talking about this suit that, in which the civil division of the Justice Department was defending Vice President Pence against an election-related suit. The reason that I raised those messages in which Jeffrey Clark basically tells Scott Perry, "Oh, the people in the civil division didn't, want to have anything to do with my version of the brief for that case or what I wanted to do with that case." The reason I raised that is because I covered the removal proceedings in Fulton County where Jeffrey Clark, trying to move his case to federal court, had argued that he had election-related duties as someone, within the civil division at DOJ, in part because he, was involved in this Pence litigation. His attorney claimed at one of the hearings that he helped direct and frame some of the arguments in that case. So it was really interesting to see these text messages that seemed to suggest that, he did not maybe direct and frame the arguments that were ultimately made in that case. So kind of what's going on there and how should we think about it? And what did the spokesperson say about it when you contacted them?
I've always been extremely fascinated by this suit, which was brought by former Congressman Louis Gohmert to try to force Mike Pence's hand days before January 6th, try to get him to say, "Yes, I have the power," get the courts to say, "Yes, Mike Pence, you have the power to choose which electors to count and which not to count." And of course, the courts didn't touch it, or they quickly threw it out. But there's been some reporting over the last couple of years that Trump was very upset with the Justice Department for stepping in to defend Pence, which it's kind of a normal function for the Justice Department to do. But I think in the context, in theory, they work for Trump, and here they are taking a position that's contrary to Trump when Trump wants Mike Pence to have that authority. What I read that text message as saying initially was kind of the same way you just described it, which was Jeff Clark saying, Perry told him, "Trump is not happy with you because of how you're handling the Gohmert situation," because Jeff Clark's name is on the brief defending Pence. And what Clark responded was, "The civil division didn't want anything to do with my brief." And so what I interpreted that as initially was he's saying, "That's not the brief I wrote, that's the brief they wrote." And what a spokesman pushed back on and said was, no. He's saying, "That is my brief. The civil division didn't like that brief. Maybe they wanted to go further. Maybe they wanted to say more." What the position that Clark's brief took was that the Gohmert, that the litigants involved, it was a bunch of the false electors were also on that suit, had basically sued the wrong person. They shouldn't be suing Mike Pence. They should be essentially suing the Congress, which sets the procedures for the joint session. Which also you can't really do because of speech debate matters and all that. But basically the DOJ just said, "You're suing the wrong person." And it was kind of a way to defend Pence without really defending Pence. It was just sort of saying the suit was procedurally deficient.
Got it. That's really interesting. Thanks.
Sure. And so, but you're right. It was a little bit of an ambiguous message, and that's why they pushed back so hard, I think.
So what else are we waiting for in that litigation? Is it, I've kind of lost track of where things are with respect to Representative Perry's cell phone, which is, I suspect, sort of the point.
It's kind of fascinating because we don't fully know. So what happened was Judge Howell, who was chief judge at the time this suit originated, ruled very forcefully in the government's favor that they should have access to the vast majority of documents on Scott Perry's phone that they were seeking, which he said were largely political in nature, weren't directly connected enough to his role as a legislator to be covered by the speech or debate clause. And so, big victory. Perry appealed that, and the appeals court put it on hold, put Howell's ruling on hold, and then sat on the case for 7 or 8 months while they considered it, and eventually ruled in September that Howell got some big things wrong in her ruling. Essentially, they said that any contacts that he had with other members of Congress about the election process were protected, even though Howell said they were mostly political. And then the conversations with outsiders, people that I just described, these cybersecurity folks, the Trump administration folks, Jeff Clark, those had to be assessed on a document by document basis to determine whether they were connected to Perry's role as a legislator or not. And it was a much more fact intensive process than Howell engaged in her ruling. Now that I thought I thought Jack Smith was going to appeal that ruling. He did not, and the mandate was issued, I think, just maybe late October, and so that the appeals court ruling is now essentially the settled ruling in that matter. What it did was it sent the matter back to the district court, now to Chief Judge Boasberg, who's supposed to now go through document by document and decide which ones can go to Jack Smith. But the wrinkle is, I'm not sure that the grand jury is operating anymore in the Trump matter. It's a big kind of a mystery at the moment. There's been no activity from them. And so one of the questions people have raised to me is, if Judge Boasberg does that analysis, there's no one to give it to. So there may not be anyone to give it to. So can he even do it? Is this thing just sort of dead and moot at this point? Or is there actually going to be some further development? I don't totally know the answer to that.
And this kind of raises the larger question, which is, what is going on in that investigation? You have the 6 unindicted co-conspirators, all of whom remain unindicted. When at the time of the indictment that's now before Judge Chutkan, we'd kind of assumed, at least I had, that indictments of some of the unindicted co-conspirators were coming. Now there's been, a good long time. There haven't been any pleas, and there hasn't been a subsequent indictment. And the ancillary activity associated with the investigation, like the, sort of collateral investigation of Perry and, a group of other, sort of actors at the more peripheral edge of the post-election conspiracy, have all sort of stopped, or at least visible, we haven't seen a lot of visible signs of investigation. Right. Do you have the impression that Jack Smith has decided we're getting through a Trump trial before we're doing anything else? Or is there percolating other activity that, it's just not overt?
I mean, this is what my colleagues and I spend a lot of time thinking about every day, trying to suss out. I think, there's experts we've talked to who said, I don't think the co-conspirators are getting charged. I think it's just not going to happen. I think we even used, and when the initial charges against Trump came down, that one of the reasons Jack Smith charged or identified these 6 co-conspirators who were all attorneys was to sort of defang Trump's, advice of counsel defense. They say, of course you relied on the advice of your counsel. They were all in the conspiracy with you. And so, and then that may not ever lead to charges, but that was sort of more speculative. And the grand jury did continue to meet for a few weeks after the Trump indictment. So we thought maybe these charges are coming. One theory of the case is that if the grand jury remains active while the Trump trial is pending, it creates all kinds of discovery obligations should they obtain really sensitive or important evidence. And those are the kind of things that can delay trial dates, can throw off the timeline. And they're so intent on trying to get this trial done as scheduled that I think they could just be staying dormant for, during the pendency of the trial, the initial trial.
All right, Kyle, feel free to jump in anytime. These are very free-form discussions. And anytime you have thoughts on any question I ask to anyone else, don't be afraid to cut them off rudely, and including me, and dominate the stage. Roger, let's talk about gag orders, because we haven't gagged anybody in a while. We have. Let's start with the 4-judge panel. And I know what you're thinking, members of the audience. You're thinking, what the fuck is a 4-judge panel? Don't judge courts really either meet in 3-judge panels or in en banc, which means however many judges are on the court in question? And the answer is New York is weird. The trial judges are called Supreme Court justices, and the judges at the Court of Appeals are the highest judges in the land. It's just old terminology. Roger, why is there a 4-judge panel in New York, and what did it do?
Well, actually, these appellate division panels, this is the intermediate appellate court in New York. It's called the Appellate Division First Department for Manhattan. Usually sits in 5-judge panels, so I don't know why there were only 4 today. But it was, they were ruling on the, if you remember, the Judge Engoron's order. It was a narrow gag order in the Trump civil case, mainly to try to get him to stop talking about his principal law clerk. And I won't name her because she's got enough problems as it is. But so he entered an order to stop him from talking about her, and he appealed, and a single justice, as you say, of the appellate division, they are also justices, stayed the order. And then today at about 11:45, the panel just lifted the stay. There was no real ruling. The order was signed by the clerk. So I don't know if there might be an explanation coming down, but I for the moment, I don't think so. So that one is now lifted again. Now, we're very interested, of course, in what's going to happen with the D.C. Circuit.
So wait, before we go to the D.C. Circuit, though, so now what is the status of, how gagged is Trump in the New York civil case, and what does that mean he can and can't say right now?
I believe, and I'm sorry I didn't look this up again. I believe he can't talk about his principal law clerk, who's been the subject of a lot of Trump's venom. And I think that's the main thing. Do you know, Kyle, is there more?
Any court staff, you're right. It exempts the judge, but any of his staff are covered by the order.
And the problem, I mean, he has made accusations. Well, there's 2 sort of odd things going on there. One is that this judge, Engoron, has his clerk sit at the bench. It's not a common thing. I think I've heard of it happening once in another context. So Trump's team has begun saying, "Oh, she's co-judging." There's no evidence of that. They do pass notes. That isn't ubiquitous. I used to do that when I was a law clerk, with my judge. So that is not a cause for complaint. The other problem is that they say that she has given over the limit for political campaign contributions. Now, she herself was running for a civil judge position for a while. And so she's actually allowed to give certain kinds of contribution. She's allowed to buy tickets to political events that are used as contributions. So anyway, they're saying she's biased. One of these organizations she bought a ticket to, supports Letitia James. I don't know the timing of these, whether this was before the case started or not. But anyway, they've actually moved for a mistrial based on these sorts of allegations and in the New York civil case. And Judge Engeron dismissed that, and we'll probably get another mandamus proceeding very soon about that. The mandamus is probably called an Article 78 proceeding. But that's sort of what's going on with the judge and why they want to, nominally why they want to criticize her. But this phenomenon came up, of course, in the DC case when Judge Chutkan was crafting a limited gag order in United States versus Trump. One of the interesting things there is that in the DC case, the prosecutors had a lot of evidence of how Trump's tweets incite harassing emails, threatening texts and emails and calls. But most of that evidence came out of the time period of January 6th, the 2020 election and the months after. So, now 3 years ago. So one of the issues that Trump's lawyers have said, well, you haven't proven that his tweets in this case are inciting violence and threats and intimidation and harassment. And what happened 2 days after the oral argument in DC is that Judge Engeron's own lawyer submitted to the First Department in New York some documentation about what Trump's tweets have been doing up there. And, you remember on October 3rd, he did a tweet about the law clerk calling her Schumer's girlfriend with a picture of her with Schumer and posing with Schumer. And that triggered, well, her cell phone was immediately doxed, her phone number, her emails, and she began to get, she says, a security officer for the court said it was 20 to 30 threats or harassing calls a day on the email, 30 to 50 on her 2 emails and LinkedIn account. And then they transcribed some of the voicemail threats coming in, 275 pages, single spaced of them. And they are all really frightening venom, which the security officer considered very serious threats. And about half of them were anti-Semitic. And it's pretty powerful stuff. After this, the day after, the government attorneys sent a copy of this same document to the DC Circuit saying, well, this case was discussed at Chutkan's hearing and it was in the briefing. Here's an update. And of course, Trump's attorney said this is totally outrageous. You can't mention this. This is irrelevant. It's another case. But anyway, we'll see if that has any impact.
And is there any, how did the DC Circuit, I mean, this was transmitted, I take it, after the argument. Is that right? That's
right. So we haven't heard, and, it wasn't bounced back or anything. We don't know how they've reacted.
So we know that that there is a filing in the DC Circuit and it has been brought to the attention of the judges, and we have no idea how the judges are, other than the transcript and oral, transcript of the oral argument and the audio of that, we have no movement from the DC Circuit on its own gag order situation.
That's right. And they also have Trump wrote a short reply to the government having sent that document.
Gotcha. So we actually have a question from Josh about the DC Circuit case. So I'm going to bring that in now. Any guesses from any of the panelists about when an opinion might be coming from the Chutkan gag order in light of the extended oral argument? Oh, and the special counsel's filing on Thanksgiving about the New York civil fraud case and the consequences of Trump's public comments. So, Roger and Kyle and Anna, do any of you have any sense of when we might be likely to hear from the DC Circuit?
Yeah, sure. I think it may be a while. That's my read from listening to the oral argument. The judges, who are all Democratic appointees, by the way, had some significant reservations about the way that order, some of the language in that order and how it could be applied. And they explicitly said, we don't want to be getting too deeply involved in political campaign. They said that they just had concerns with the vagueness of it, which were some of the same ones that Trump had raised about how you apply it. And so our read was that they were very likely to sharply narrow the order that Judge Chutkan imposed, but to maintain some sort of gag on Trump, but it may be much more limited than what Chutkan issued. It could be, completely shorn of some of the teeth that she was trying to put in it about the special. I mean, the judges of the circuit were saying, why can't Donald Trump call out, line prosecutors who he doesn't like? Why is that something he's not allowed to do to just criticize the conduct of the case against him? Why can't he, get into some of these areas that actually didn't even seem that controversial in the Chutkan order? And so given the questioning, I think they're going to take their time on it and craft something much, and in the meantime, the Chutkan order is on hold. It's been suspended. And what's interesting about that is Chutkan very explicitly said, you shouldn't be attacking the family members of people involved in your case. And now Trump has, since the order was put on hold, gone after Jack Smith's wife and his family. And in New York, even with the gag order in place related to Judge Engoron's staff, he's been attacking Judge Engoron's wife, who allegedly had been posting social media posts that were critical of Trump. But as we learned today, the court is now disputing that and saying she never posted anything about Trump. Actually, minutes before we came on here, the court said all those allegations that Judge Engoron's wife was posting anti-Trump content are false. But Trump has nevertheless been attacking her daily while this is going on. And so, I'm curious to hear if there have been threats generated off of that, because attacking people's family members, Judge Chutkan said that was so inherently wrong that she didn't need to put it in the order because it was so clearly out of bounds. So that's just another interesting wrinkle in all this too.
Roger, what do you think? Do you agree with Kyle that we're going to look at a protracted period before which the order is sharply narrowed?
Well, I agree that it's going to be narrowed. Likely will be narrowed. That was the impression I got too. I actually was a little surprised. We don't have a ruling yet. I thought they would be rushing because there is urgency in not having a gag order on certain matters. And but I agree. It sounds like there's not going to be any. It didn't sound like. They're not going to prevent him from criticizing Jack Smith or his line prosecutors. A weird thing about the order is that it actually doesn't mention the family, even though the judge she said it goes without saying. But I don't know if it literally goes without saying if you don't put it in the order. And so I don't know the status of the family. And then Judge Nina Pillard was saying, she actually had language to replace the word targeting in the order. A lot of people had criticized the word targeting as what does it mean exactly? And she was proposing to both sides, what if you replaced it with such and such? So I do think they're going to tweak it and narrow it, but I thought they'd be moving more quickly.
Anna, what do you think? Are you closer to Kyle, sharply narrowed and slow, or closer to Roger, quick and more gently narrowed?
I mean, look, I'm going to take the middle ground between those positions. So maybe not as narrowly tailored as Kyle thinks, but and also maybe not as fast as Roger thinks, somewhere in between. But we'll see. I mean, I don't know. I just don't have a good sense of it based on the oral argument, and I think that it's hard to tell. But I defer to Roger and Kyle, or I would if they didn't have such differing views, because they're the pretty men courthouse experts and the DC district court and DC circuit experts. So I think it does say a lot, though, that they have two very different reads on it.
But I will say we don't know that, to your point earlier, that whether this information that was supplemented based on what happened in the threats generated in New York that are hard evidence of what Trump's tweets do, will that change the calculus? Because we haven't heard the circuit weigh in on that. That could point in favor of Roger's interpretation here if the court takes that seriously. And every time the court suspend these gag orders, Trump just adds more. I mean, just pours more coal into the furnace about justify the original gag orders. And so that may change the calculus and speed it up.
Okay, I just want to weigh in with what the right answer is. The right answer is that Roger is correct on the speed. The exact percentage that will be lopped off of the substance of the gag order is 19. And so we're going to have 19% shave, and it's going to be just a few more days. Thanksgiving got in the way. Judge Pillard had a lot of turkey, and it's just, they all had a lot of dishes to do. All right, Roger. One thing that Thanksgiving has gotten in the way of is the Colorado. Our discussion of the Colorado court decision on Section 3 of the 14th Amendment. And I want to apologize to everybody about this. They released this right before the holiday. We got a very critical note from a law professor who's involved in this, accusing us of a deafening silence on the subject of Colorado Section 3. If you're watching, Professor, I'm my humblest apologies. We're a small operation, and when a court dumps a major opinion that is not an emergency to comment on right before a holiday, sometimes we're going to celebrate the holiday. So I hope you, Professor, had an excellent Thanksgiving. I certainly did. But Roger, what did the judge in Colorado do? It's one of the strangest rulings I have run across in a while.
So, Judge, this is a state court judge, Sarah B. Wallace, and you remember there was a week-long trial, and she finally gave the ruling, and she ruled I'm sure you all know this, most of it, the headlines. She ruled for the petitioners on almost everything, down to including that January 6th was an insurrection, that Trump incited the insurrection, that Trump engaged in insurrection within the meaning of Section 3, but that Section 3 doesn't reach presidents. That was the ruling. And so this case could have been thrown out before trial on that issue a long time ago without the trial, but she wanted to hear from professors on that question as well as on some of the others. That's what she said. And what the result is, we now have a very, very full record that both sides can appeal, and all of the issues go up to the states. They go directly to the state Supreme Court because this is an expedited proceeding under a particular Colorado statute designed to challenge the qualifications of people on the ballot. And So it surprised me. I think it surprised everybody. It was, and also I think of the very many reasons you could, wriggle out of having to rule on something like this, I don't think many people thought that this particular argument was where it would be the hangup. I think a lot of people thought, well, there's a big issue about whether Section 3 is self-executing. Does Congress have to enact a particular, cause of action or a way of judging somebody's qualifications? There were, you could have dismissed it on sort of technical state grounds and you could have said, well, it's a primary. The parties are in control of primaries. We can push it off. There's a trillion ways, and she ruled for the petitioners all the way down the line. And she actually said the insurrection question was, a fairly easy one. At least the insurrection part. I'm not saying the engaging in or the incitement, but. So it was really pretty remarkable, and it came out on a Friday. The petitioners, I don't know how they did it, filed their appeal brief, the full brief, not just notice of appeal, Monday. They went through the weekend, and it was, and it's a good brief. And so now, and we're going to get here. It's very expedited. Wednesday, December 6th. Will be the oral argument at 1 p.m. Mountain Time and 3 p.m. our time, Eastern Time. And so it's a pretty remarkable thing.
All right. So for those who are confused by the idea that you could have a highly developed record, that there was an insurrection, that the president engaged in it, and are saying to themselves, wait a minute, are you saying that the Congress that was aware, that Jefferson Davis, if Robert E. Lee had run for president, it would not have prevented, this is a Civil War amendment. Is this argument a serious one in your view, or is it a kind of a gotcha that, how seriously should we take the idea that the 14th Amendment Congress, the radical Republicans, might have exempted the presidency and the vice presidency from the disqualification?
It's a serious argument now. The judge admitted she could not think of why they would have done this. It does seem to make no sense. But, the conservative jurisprudence, plain meaning, textualism, you're not supposed to care about intent so much. It's sort of what do the words say and how would they have been understood? Clearly, they weren't understood this way. In terms of intent, there was enormous amount of talking about the need to keep Jefferson Davis from running for president. And, each time there was an amnesty act after the Section 3 was enacted, there was discussion again. We have to craft the amnesty act so it doesn't cover Jefferson Davis because we don't want him running for president. That would be crazy. And so they thought this covered him. But and I should say for readers, for listeners, there are really two arguments that are semi-distinct, or some people think they're distinct and some people don't think they're distinct, but there's two arguments because you remember the way Section 3 works is it's incredibly gnarly. And the idea is, first, who is covered by it? Well, you have to take an oath to support the Constitution. In the process of taking certain list of positions. So that's the triggering event, the oath taking, and the oath to become president is not mentioned specifically. It says senators senators, representatives, and officers of the United States. Most of us say, duh, that, but a case can be made, blah, 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 lawyers,
No, the core of the argument is that the president is not an officer of the United States.
Yeah.
He takes a different oath.
Exactly.
And that the presidential oath, and therefore he is not covered by the and other officers, right?
That's right. And then the second half of it is, if you take that oath and then you engage in insurrection, you are barred from holding a similar but slightly different set of offices. And it's described there as any office, civil or military, under the United States. So the question is, okay, does that include the president? And interestingly enough, one of the professors who's been most adamant from the beginning, or at least, from early on, a couple of these professors that have been most adamant, Seth Tillman and Josh Blackman, that the president is not, his oath is not included, have not committed on the other half of it. They don't know about, does it bar presidents? They say the triggering oath of a president doesn't count, but they haven't taken a position on the other half of it. So these are distinct points.
The judge emphasized this, and it's actually a really fascinating part of it is Trump is sort of is sort of a unicorn in all this, because he's the only president who hasn't taken one of those other oaths. Just because he came from where he did is not a elected official in any other capacity. And so it just, you couldn't have crafted a ruling like this for any other person that would somehow result in him still being eligible to be on the ballot.
Right, because he's held no previous office, right?
Yeah.
All right, Professor, our deafening silence has been broken. We acknowledge that there has been an important event in Colorado at the district court level, and we repent and humbly apologize for our silence over Thanksgiving and the week around it. All right, Roger, before we move on to Coffee County and get bogged down in the minutia of Coffee County, let's talk about the minutia of 1512C, which, for those who don't remember, is the obstruction statute that a whole lot of January 6th prosecutions turn on. This is now before the Supreme Court, and they're going to decide whether to decide about it, right?
Yeah. The cert petition is before the court, and the conference is tomorrow, as I understand it. So this is on, there are really two challenges relating to 18 U.S.C. 1512C2. This is the felony that is sort of one of the most important felonies in January 6th criminal cases. At least 317 people have been charged with it. Trump is charged with essentially two versions of it in District of Columbia. And so it's an important statute. And there are two challenges. One has to do with what does it cover? It is called corrupt obstruction of an official proceeding. And so can you corruptly obstruct an official proceeding through violence, or must it be only through tampering with evidence? So the judges below in the District Court of Columbia, almost all of them, at least 15, said that, you can obstruct it with violence. But one said, no, it has to be tampering with evidence. And that case is now coming to the DC Circuit's sort of affirmed. It was three different opinions. It was very hard to put it all together, but it affirmed. And now that one is a conference before the Supreme Court. And as I understand it, so Monday at 10 a.m., they might grant cert, they could deny cert, or they could relist, which means you listened in for nothing. It just gets pushed off another till the next conference.
And what are you realistically expecting here? Kyle, this goes for you too. I look at this and say, there's no conflict in the circuits. The DC circuit is split on the question, but so what? There actually is some controlling law in the DC circuit. And so I'm not really sure why the Supreme Court should grant cert in it. On the other hand, I could also look at it and say, if we're thinking about this from a mischievous conservative judges who want to throw a wrench in January 6th prosecutions combined with earnest conservative judges who actually have a long history of narrowing obstruction statutes and certain other statutes, in particularly as it relates to white collar cases, combined with their liberal colleagues who feel the same way about the same statutes. Maybe you see, 6 votes, 5 votes, or 4 votes to grant cert on the theory that the government's been too aggressive here.
I mean, the only thing I'd say is I'm not sure these are the right cases, the ones that are currently pending to reach the most important issues on this, because the 3 cases that are pending before the court right now are cases which all involve violent defendants. And so the question of whether you corruptly obstructed an official proceeding is kind of settled for all of those cases. The whole reason that got to the appeals court was because Judge Nichols, the one district court judge who broke from all of his colleagues, said you have to physically destroy, evidence, take papers out of a desk, to obstruct an official proceeding. That was kind of an out of left field sort of argument that the circuit pretty easily dispatched with, even in their split ruling on this. But the issue was that even in the circuit, they said, we didn't really take briefing on what it means to corruptly obstruct an official proceeding. The definition of corruptly is a huge question mark hanging over the obstruction law, but these cases didn't really reach that, and the circuit was never briefed on that. There's another case that was resolved recently called the Robertson case, in which someone was not charged with, he I think did he impeded police officers in some way, but it wasn't quite the same violent assault that these others were charged with. And he challenged it. And in that case, corruptly, the definition of corruptly was at the heart of his appeal. And that, to me, is one where the Supreme Court may be more interested in trying to settle this question, and it's just not quite moving along at the same pace as the others.
What do you think, Roger? Is they going to pass on this one and wait for Robertson?
There is another. Well, it might make sense, and there's another aspect of this one that's different from Robertson, which is that this one is an interlocutory appeal. Mm-hmm. He hasn't gone to trial. And it usually, the Supreme Court doesn't usually take criminal interlocutory appeals. You can send it, let it go, and if he's convicted, fine. Then you can appeal, and I'll hear the whole thing. So that would be one excuse. The Robertson case, there's another interesting thing. Strategically, in this Fisher case, it was called at the D.C. court level. It will now probably have a different name, but they chose ordinarily, they got three rulings from 3 judges. So ordinarily, you might move for rehearing en banc. You have all these judges on the court. I don't know how many there are on the DC circuit, but maybe 9 or 12 active duty. And so why not clarify this? Why leave it with 3 different rulings? Strategically, the defendant didn't want to do that because it's a mostly Democratic bench, and it would have made the ruling stronger in favor of the Department of Justice. So they only moved for rehearing, a panel rehearing. That was denied. So it went up in this crazy position. Now the Robertson case, the one Kyle is talking about. They are moving for rehearing en banc of their case, which focuses on the corruptly issue. But they say in order to understand that, we need the en banc court to rule on what the other case, Fisher, meant, because they're interwoven. And so the sensible thing to do, if they realize this is happening, is to say, yes, let's not take this one. Let's wait to hear what happens with Robertson. Maybe we get an en banc ruling, and so on.
All right. Let us go to Fulton County and from there to Coffee County. Anna Bauer, first of all, let's start in Coffee County. You had another giant tome this week on the machinations in Coffee County. We have a whole podcast coming out about it tomorrow. So we're going to go a little bit light on it here. But what is the 60-second version of everything wrong with the Georgia Bureau of Investigation's report on Coffee County?
Right. So we do have a podcast coming out tomorrow morning. So everyone, please check that out for a longer discussion between Ben and I about this. But the short elevator pitch version is that the GBI conducted this separate investigation that was in parallel with the Fulton County District Attorney's Office. They were investigating these things at the same time, but the GBI has a wider jurisdiction than the Fulton County District Attorney's Office, although, of course, Fani Willis was able to expand her probe because of the kind of specifics of bringing a RICO prosecution. She's alleged that the Coffee County voting system breach was a part of the RICO conspiracy to overturn the election. But she also is more limited in terms of resources and just in terms of the ability to have a dedicated probe that's just focused on the breach of voting systems. And we know that in part because there are 30 unindicted co-conspirators in the Fulton County indictment. And some of those unindicted co-conspirators are people who are alleged to have either participated in planning the breach of voting systems in Coffee County or distributing the data that resulted from that forensics copying and testing. But so all of that is to say that it did matter what the GBI was doing and whether they completed a thorough and complete investigation. Based on their report, it seems to be the case that they had some really striking and quite baffling omissions in terms of, leaving things out that could connect the dots between this, alleged conspiracy between the former president's legal team and some people who are, rural folks in South Georgia. That's a pretty serious allegation that's in the Fulton County indictment, and it seems to be the case that you would think that there would be a serious investigation of it, but they only interviewed about 15 witnesses in 13 months. And most of those interviews were, took place in less than an hour. Most of those folks were people who were at the, Coffee County level. They really didn't seek interviews in many cases with people who were, maybe former Trump campaign officials or people who were involved with the campaign who seemed to have some kind of at least personal knowledge of what was going on and maybe what was leading up to this breach. And they basically just relied on civil litigation and the January 6th committee report and depositions, and instead of kind of doing an independent investigation. So I hope everyone does check out that conversation between Ben and I for longer discussion about some of the significance of all of this, because I do think it's important.
And for those who are listening on the podcast, you can find it on the Lawfare website. The story is what the GBI missed in Coffee County. Okay, so meanwhile, Anna, we have had a hearing go by in which the judge decided not to lock him up. and him being Harrison Floyd, who is not to be confused with Harrison Ford. And then we have a big hearing tomorrow that is notable because it is going to debut Trump's crocodile boot wearing Georgia lawyer. So let's start with Harrison Floyd, who is not to be confused with Harrison Ford. Who is this guy, and why did Fani Willis want to lock him up? And what was awesome about the hearing?
So Harrison Floyd is one of Trump's co-defendants in Fulton County, which we are now down to 15 co-defendants after 4 of those co-defendants have pleaded out. Harrison Floyd is indicted in addition to the larger RICO conspiracy. He's indicted under that kind of prong of the conspiracy that involves this pressure campaign and intimidation, alleged intimidation campaign against Ruby Freeman, in which, prosecutors allege that Harrison Floyd and some other co-defendants tried to, pressure her into claiming that she had committed electoral fraud when she had not, in fact, committed election fraud. And what happened, of course, just by way of background really quickly, if folks remember before the Thanksgiving holidays, Harrison Floyd had been making statements about some of his co-defendants and witnesses on Twitter. He's a prolific Twitter user. And he made some comments, for example, about Jenna Ellis, his former co-defendant, in which he called her a mess and said that she had accused her of lying in her proffer video after her guilty plea. He also talked about Brad Raffensperger and Gabe Sterling, who are Secretary of State officials in Georgia who are presumptive witnesses in the case. He called them pieces of, and then he, used the poop emoji.
Can I just say this hearing was so prim about referring to the
fecal matter,
the fecal matter emoji. Guys, we're all adults here. You can say he called them a piece of shit.
Yeah,
I know. Like Fani Willis was really like, I don't want you to describe that emoji. It was awesome.
Right. And so we had this hearing, and I think that this hearing, the reason I want to remark or want to talk about it just for a moment before we move on to tomorrow, a preview of tomorrow's hearing, is that it was our first time seeing Fani Willis in court arguing a motion. That's something that's really rare to see the district attorney herself actually show up and argue a motion. Usually, it's the line prosecutor. It's, in this case, there's a dedicated prosecution team who has effectively done all of the arguments except for, to my memory, there was one time after the special grand jury finished its work and Fani Willis kind of did a little introductory, statement. But other than that, she has not personally appeared since the indictment was handed down in August. So it was really interesting to see her in court arguing before Judge McAfee. She delivered a really, fiery
she is an
argument. You could tell it was something
impressive trial advocate. I gotta say, people have a lot of hot takes about Fani Willis, but that woman knows how to argue in front of a judge, and she lost this motion. But she was compelling. I just think it was a really interesting portrait of her.
Yeah, and it was a really tense hearing, I will say. I was in court that day instead of, following it on the live stream. And there were a lot of things that kind of just were happening in between, moments in between, arguments where there was just really high tension between the defendant, Harrison Floyd, and the prosecution team when we were taking breaks before, Judge McAfee entered a new bond modification. He was, making comments about the prosecution team. He was very defiant. They were, of course, very, eager to argue this motion forcefully. So it was really just a very dramatic hearing. And Judge McAfee ultimately decided to just modify the terms of his bond agreement rather than, send him to the Fulton County Jail for the remainder of, or potentially for the remainder of the duration while he awaits trial, which could be, more a year or more at this point. So it's seems to be that he was focused on giving Floyd a stern kind of warning or talking to, but he ultimately just decided not to revoke his bond.
Yeah, Judge McAfee, once again, the man with the hardest job in this entire business. I mean, everybody else he's got just as much Trump as everybody else, and he's got 18 other co-defendants. A whole lot of them are pretty nuts. And Harrison Floyd, who is not to be confused with Harrison Ford, is an unusual character. And this was just another day at the office. And I walked into that hearing having no idea what the judge was going to do. And he listened to everybody. It was like a 3-hour hearing, maybe more. And he continues to show an independent streak. So for those of you who hate the Federalist Society and think that all Federalist Society jurists are, Eileen Cannon, remember Scott McAfee, FedSoc, University of Georgia, and only a few years ago, too. He's barely out of law school, this guy. All right, Anna, we are going to go to audience questions in a moment, and we're going to go to questions as soon as Anna finishes telling us about tomorrow's crocodile boot debut of Steve Sadow, super lawyer for Donald Trump, who I have to say I'm excited to see him argue. What are they going to be yapping about, and what kind of boots do you think he will be wearing?
I gotta go. He's probably gonna wear the Caymans. I got the Cayman crocodile boots. I feel like I think twice when I've seen him, because I ask every time that I see him in court, and I think it's twice now that he has been wearing the Caymans.
Can you get a picture of him with the boots?
Because
I do think that's
yes.
Like something that for the dispatch, we need a boots picture.
I agree. I think we need a boots picture. I am still upset that because Ken Chesbro pleaded out, we never got to use the Impala Loya pictures of Scott Grubman that we had. But
they will not go stale.
But I will also mention that there is a profile out in the New York Times today by Richard Fawcett, and it's very good, but he did not mention the cowboy boot collection. So I just, think that if anybody needs their exclusive reporting on the Steve Sadow's cowboy boots, then Lawfare is the place to be.
That's right.
So I will say, in terms of tomorrow, we have a lot of motions to get through, and I don't think we have time to discuss all of them. Some of them are motions that Judge McAfee, in the Chesbro and Powell, speedy trial hearings, has already ruled on some of those motions. It's things like, the Electoral Count Act and Supremacy Clause. It's things about whether the indictment sufficiently alleges a RICO enterprise or, continuity. So there are things like that. There's also, I think, though, what the main issue that I'm looking at tomorrow that seems to be at the top of Steve Sadow's mind is the First Amendment arguments that they have adopted, which Ray Smith had offered in one of his motions. It's a very kind of vague and broadly worded motion. So it's kind of hard to tell exactly what they will be arguing. And in fact, the district attorney's office has made the argument that, it's so vague that they should be, kind of precluded from arguing it, or that they should have to expand on it in writing and allow the district attorney to respond. But we do know that Steve Sadow has this on his mind because he filed a supplemental motion in which he said, even though Judge McAfee's already ruled on this with respect to Chesbro and Powell, and even though he's already denied it, here's why we have some supplemental authority, which means that basically, Judge McAfee, you weren't right when you ruled on Chesbrough and Powell's arguments on this. You can, in fact, make a different decision here. And then also, Steve Sadow says in that motion, even though he's already adopted this one, he wants to be able to submit his own kind of independent First Amendment argument on behalf of Trump. So there may be some discussion about, to what extent, can he go beyond the scope of what he's adopted through Ray Smith's motion? So it's all going to be a little bit confusing because it's not entirely clear, what exactly they're arguing, although it does seem to be that this is a First Amendment as applied argument. So they're saying not that the statute, is itself unconstitutional under the First Amendment, but it is, as applied to the facts of this case, unconstitutional because, it's political speech and that kind of thing. Another thing that's at issue that I'm interested to see what happens tomorrow is this motion that Steve Sadow has submitted to Judge McAfee about getting discovery, or at least kind of compelling the district attorney's office to ask the special counsel's office for, certain kind of descriptions of the relevant evidence or witnesses in the federal case that's in discovery, so that he can ascertain whether or not any of that might be things that they need in terms of Trump's defense in the Fulton County case. So that'll be interesting, but there's a lot more there. I'm sure it's going to be a long hearing, and I'm interested to see what happens.
And what time is that tomorrow?
That's at 1:30 tomorrow. I'm actually a little bit surprised that he set it for 1:30 because, it seems like it's going to be a very lengthy hearing. So who knows? We could be there for a long time, but, I don't know. But yeah, 1:30 tomorrow, and we'll have it up on the Lawfare No Bull after the hearing's over so that people can listen to it wherever they get their podcasts.
Right. So you can listen to that hearing as well as the Harrison Floyd hearing on the Lawfare No Bull feed. Okay. We have 6 questions. We're going to get through them all. Julia, unmute yourself and the floor is yours.
My question is about the appeals that the DOJ announced after the Oath Keepers and Proud Boys sentences, that they intended to appeal those sentences. The Oath Keepers announcement, I think, was in July, and the one about the appealing the Proud Boys sentences was last month, I think. But I haven't seen any reporting that they have been filed. Can you talk about this? Is this something that the DOJ does often, that they signal they're going to do something and then they don't do it, or what?
Oh, they did it. Roger, what can you tell us about the Oath Keepers and Proud Boys appeals?
I don't think anybody on either side has yet actually filed the first appellate brief. Do you know, Kyle?
They haven't yet, and I do have to check back on the dockets to see if there's been any updates, but my understanding is they've filed the notice of appeal and get the ball rolling, but you're right, no substantive briefs yet, which I'm also eager to see.
But those are, you wouldn't have expected that. Well, so wait a minute. The Oath Keepers one, you might have expected by now, but the Proud Boys one, you wouldn't have by now, right?
That's right. We're nowhere near with respect to the Proud Boys, but we are getting close with respect to the Oath Keepers, I would think. But I have no reason to doubt that they're going to, especially because there's no question that the defendants are appealing, and so there will be
a cross appeal.
Yeah. Mm-hmm.
And there's a very simple reason why the government will pursue this appeal, and that is these are significantly below guideline sentences that affect a whole lot of other sentences, both those that have been already imposed, because if you set Enrique Tarrio and the One-Eyed Man here instead of here, then nobody can go above. People have to be scaled down. And so it affects a whole lot of other sentences. And the government is going to take the position that they should have received a guideline sentence. And that means a lot more years than they both got. People a lot of people, including me, don't love federal sentencing because it's really, really harsh. And I'm, not personally uncomfortable with the sentences that either of those guys got as deficient. But if you represent the criminal division of the United States or the special counsel's office, which in this case, the relevant actor is the U.S. Attorney's Office and the criminal division, you want to push those sentences as high as you can, both for their impact on the individuals and for the other people who that creates a ceiling for.
I actually sort of disagree. I think these are the bad facts to take these sorts of appeals, especially some of the Oath Keeper cases. And the use of the terror enhancement in these cases is also unusual. They're not typical terror enhancement cases. They seem like losers to me. I'm surprised they're doing this.
So we had this argument at the time of the sentences, and Roger is, in this case, disadvantaged by having actually sat at the trials and knowing what he's talking about. I have no such encumbrances and simply know how the Justice Department behaves. And when they get a deficient sentence in a high-profile case and it caps other sentences, they do appeal it. And so I don't think we're actually disagreeing. I think you're responding to the cases that were presented, and I am describing the typical behavior of the United States Department of Justice.
I'll also mention that not many January 6th cases are being capped by these, because like the 4 Proud Boys have 4 of the top 5, something like that, sentences of any of the, any January 6th defendant, the one exception being somebody that had 38 priors.
No, but they're capping each other's sentences. So if Stuart Rhodes is, what is he, 18 years then all the other Oath Keepers are going to be below that. And so if you're the Justice Department and you can bump him up to 25 years, then he's not, limiting the others in the same way. And I just think that's going to be the way they think about it. What do you think, Kyle?
I think that's right. I think there was also the floor that Judge Mehta set for some of these Oath Keepers was kind of surprising. I think there's a principle at stake in terms of the actual crime of seditious conspiracy, which I think the character of a seditious conspiracy is so grave that the government wants it to be reflected in the sentences, at least in the guidelines range, because it's often analogized to treason, and at least sometimes in the legal setting, it's analogized to that as, but one of the most serious crimes you can commit against your own government. And so I think there's something, I think Judge Mehta, like you, says federal sentencing is overly harsh. The terror enhancement jacks up sentences so dramatically that it's out of whack with what these people should be getting, and that's why he did what he did. But I think prosecutors will look at that and say, if you commit seditious conspiracy against our government, a 1 year or 2 year sentence for even for some of the people on the lower end of the conduct spectrum, it seems hard to imagine, hard to justify. And Mehta has sort of boxed in some of the people, Ed Vallejo, who managed the weapons cache in Arlington while the Oath Keepers were storming the Capitol. I think he got 3 years, with one of those being on home confinement. So it was kind of, Mehta set a pretty low floor.
Yeah. So I think whichever, I have not studied the individual cases at a level where I could say, here's what I think the appropriate sentence is for that. I certainly defer to Roger on that. I do think if you want to understand what the Justice Department is doing, the factors that Kyle just laid out and that I laid out are highly explanatory of DOJ behavior. All right, we got 5 more questions to get through, and we can't spend as much time as we did on that one. Nathan asks, hypothetically, if Trump is convicted in D.C. and Fulton County cases, and given that we are talking about a former potential or future president, one that a future Republican president will likely pardon anyways, Generally speaking, what kind of remedies, penalties, and other measures are available to the prosecutors, judges, and juries to consider? Would home imprisonment be a likely measure, at least for the federal cases? I think this is an easy question because the answer is nobody has any idea. There's no law, there's no precedent, there's no anything for this, except to say that judges can be creative, the Bureau of Prisons can be creative, the Secret Service will make demands because they continue to have a protective function with respect to Donald Trump, and the state of Georgia, I don't know how creative Georgia confinement can be, but I think you should expect everybody to operate in a zone of working stuff out in a way that allows a punishment to be effectuated in a fashion that's consistent with different actors' needs. Anonymous attendee asks, how is the Colorado judge's ruling on Trump's disqualification based on a plausible reading of the 14th Amendment and any existing precedents? What is the reasoning behind the interpretation? So we sort of covered this. The work to understand the reading here, there's really two things to read, in my opinion. One is the work, the opinion by the judge itself lays it out pretty coherently, and it closely tracks the argument that Roger summarized it very well. That it has to do with the definition of officer and the differences between the presidential oath and the specified oaths, and then the professors who have most vociferously advanced this theory in academic writing are Josh Blackman and Seth Barrett Tillman, who sometimes write for Lawfare, but in this case, they have written this material elsewhere. Josh has a law review article on the subject, and as Rogers says, it focuses on the first half of this. That is the question of whether the president is an officer. All right. The next question is Jacob. Jacob, unmute yourself and the floor is yours.
Thanks. I know we didn't talk about Florida because who wants to? But and I know it's popular to speculate that Judge Cannon's in the bag, but isn't it just as likely or as possible that she's just bad as a judge? She's no Scott McAfee.
Porque no los dos. I mean,
exactly.
Like, well, right. If you're just bad, you tend to make errors in all kinds of different directions. The striking thing about Judge Cannon is that she has only erred in one direction and has done so on a kind of dramatically repeat basis. And I think until I will remain suspicious of her until I start seeing like really bad errors that tend in the government's favor. But that's just me. I mean, look, if you want to speculate that she's just a lousy judge, that's a very fair and maybe generous interpretation. I don't know. What do you think, Roger? And you, Anna, you guys have actually seen her in action.
I don't think it's just inexperience. There is a, I think, as you say, there is a trend and a uniform direction. I also think if you look at the direction, this gets a little, this is my Dr. Parloff's corner part of the program, but getting psychological. But when it comes to ruling for the government, which she sometimes does, she won't issue a ruling explaining that. She just does it. And she does it very quietly, as if she doesn't want to draw attention. And then if it's a ruling against, or she will propose, or she gets involved. She suggests that, the defense lawyer should look into brief this for me, brief this argument you haven't raised. And those she will write about, even if there's very little there. So to me, it's a very strange picture.
All right. Penultimate question. Is the Colorado Supreme Court likely to send the question of Trump on the ballot back to the lower court, as opposed to infirming in part and reversing in part, in which case presumably both sides would try to appeal to the Supreme Court? Roger, my impression is that we don't know how they're going to handle it, but whatever they do, I think it's likely to go to the Supreme Court before it goes back to the trial court, right?
Yeah, I think they understand that time is of the essence. They've put a very expedited schedule. I think they understand they're not the final word also, probably, and that the important thing is to rule. And that's how she said that early on. She said, look, I'm not deciding. My role is to get this to the Supreme Court, in a way so that they can make these decisions.
Jonathan, you get the last question today, and it's clearly for Anna.
Do we know why we haven't seen more guilty pleas in Georgia?
Yeah, it's a good question. I kind of expected we might be seeing some more after, that first wave of them. But I think that there's a few... for each defendant, it's kind of unique, and it depends on, you've got a group who are going through removal proceedings, so they might want to try to wait to see what happens with that. You've got a group who I think are very convinced of their innocence and of they're kind of true believers, so to speak. So that's people like Harrison Floyd and Kathy Latham, and people who might have, reasons to not plead out because of, some of the political or ideological stuff that's going on in the background. And then you've got, other groups of people who I think it's just the case that they, and I should say also, you've got a group who aren't getting any plea deals, which, The Guardian reported, CNN had reported previously. And then you've also got some people who, have really good defense attorneys, and they're going to wait until some of these dispositive motions are actually filed and argued before they maybe move towards a plea agreement. But I definitely think we're going to see more. It's just a question of when and who. But I don't have a solid answer for you on that. I'm sorry that I don't. But Ben, Roger, are you guys surprised we haven't seen more, or what do you think's going on there?
I'm not particularly surprised at this stage. I would think you have the raft who use the threat of a quick trial, and now there's a good long time before anything serious is going to happen. So I'm not sure there's quite as much of a rush at this point, particularly for people who aren't necessarily paying by the hour, but maybe have retained counsel for for a lump sum.
Right. And I should add, too, that there's Judge McAfee hasn't set a trial date, of course, but there is a motion pending that Fani Willis has asked for an August 5th trial date. In that motion, she also asked him to set a final plea date for, I believe it's in mid-June or maybe late June. And then, the idea being that that's the last date in which a defendant could enter a negotiated plea. And then, after that, it would all be, non-negotiated pleas. You can do that in Georgia, where you just kind of go before the judge, plead guilty, and hope that they take pity on you and give you a lenient sentence. But in those circumstances, after that final plea date, Fani Willis says that the state will recommend maximum sentences. So I expect that, depending on when Judge McAfee sets that final plea date and the trial, once we get through some of these dispositive motions and we get closer to that date, that's when we're going to see a kind of avalanche of people potentially pleading out.
We are going to leave it there. Thank you all for joining us. The Lawfare Podcast is produced in cooperation with the Brookings Institution. Our audio engineer this episode is the long-suffering Anna Hickey of Lawfare. Look, folks, you can see we have fun doing this, and the audience has fun. They ask questions. Sometimes they have me read them. Sometimes they ask them themselves. It's good fun, and you should join them. And today there were like over 70 people in the live Zoom audience, and you could be one of them. Become a material supporter of Lawfare. This week was Giving Tuesday. You're going to hear this on Giving Saturday. So become a material supporter of Lawfare. Lawfaremedia.org/support. You can do it. You know you want to. There are like 5,000 people who have watched this on YouTube. Every single one of them should be a material supporter, and that includes you. The Lawfare podcast is edited by Jen Patja Howell. Our music is performed by the one, the only Sophia Yan, who has moved again, this time from Taiwan to Istanbul. And as always, thanks for listening.